So your company wants to engage in open innovation. Open innovation involves some kind of collaboration with a third party. It could be a company of the same size, similar experience with competing activities, or it could be an entirely different company, such as a startup with a niche activity your company may need. Now, this open innovation collaboration may entail difficult questions relating to IP. For example, what is protected? Who's the owner of the IP? And if nothing is protected, who can do what with what has been discussed? Now, these are very difficult discussions, and they can cause a lot of discussions and a lot of conflicts between open innovation partners. So before the open innovation event, you need to know what your company has protected under intellectual property rights and what it considers trade secrets. Intellectual property rights could be copyright, patents, design rights on any type of technology that you can imagine. So it could be software, it could be chemical processes, it could be pharmaceutical inventions, it could be anything. You need to know in advance what is protected and how it is protected. Do you have a copyright? Do you have a patent right? It's not the same things. Depending on how things are protected, there are certain things you can and cannot do. Importantly, what we've provided in the terms and conditions is that all this background IP remains with your company. So no matter how enthusiastically you're going to be sharing this information and the knowledge about this IP with your team members, your company will remain the sole owner of this background IP. Secondly, about the trade secrets. Now, what can be trade secrets? Trade secrets can cover a whole wide range of information. It could be algorithms, it could be sales numbers, it could be your suppliers, your clients, it could be information about your technology, about your commercial strategy, it could be anything. You need to know in advance, go check with your lawyer, you need to know in advance what your company considers trade secrets, confidential information that gives it a competitive advantage compared to other companies. This information you mustn't share with the team members, no matter how much confidence you have in them, no matter how nice they are and how enthusiastic you are about the process, you mustn't share this information. Now, at the event, you will be working together in teams with other companies or participants from other companies. You might be onto something really good, and you might end up creating some new process, new ways of thinking, algorithms, whatever that your team will be pursuing. Now, some of these creations might be protected under copyright, under patent. There might be a possibility to apply for a patent. There might be IP as defined in the law. Importantly, we have not provided any rules to allocate ownership other than what is provided in the law and what is provided in your contract, so the contract between you as a participant and your company that is the contracting party in Hack Utilities. So we have not provided different rules, standard rules will apply. However, we do have a rule of attribution. So if something cool comes up, you engage yourself to mention, if you're going to exploit this opportunity any further, you engage to mention your team members, so the people who have been working with you in the team, and also Hack Utilities. This is not a matter of law, it's a matter of courtesy. Now, after the event is done, you might think there's some real opportunities to commercialize, to further develop one of the ideas and to commercialize the ideas. Again, we have some rules. If the creations that are the result of the Open Innovation event are protected under IP, you will need to respect the rights that your team members may have. So you may have to involve them in your commercialization process. But even if they're not, you, on a contractual basis, engage yourself to go and check with them. You need to keep track of all your team members and their companies, and you need to invite them ask them if they're interested in pursuing the commercial opportunity, yes or no. None of the companies is under any obligation to do so. So you're free, your company is free to say, yes, we're interested and we want to engage in further discussions, or no, it was fun, but this is where it ends for us. So you're free to pursue this opportunity together. If there's other team members who are interested in pursuing this commercial development of the idea that you've come up with at the Open Innovation event, then you need to engage in a fair and a solid discussion. Try to collaborate with your team members in order to pursue this event. So your lawyer may have identified some vulnerabilities in the protection of the trade secrets. What happens if some information gets disclosed that shouldn't have disclosed? Normally, between disclosing parties, an NDA, a non-disclosure agreement, exists. But in this case, we have a different situation because we have company A that's participating in the Open Innovation event that has a contract with hackathons. We have company B that has a contract with hackathons. But between companies A and B, there's no contract. Meaning that if company A discloses confidential information to company B with the restrictions that company B can only use this confidential information during the hackathon that is being organized, but company B actually uses this information for other purposes, company A does not have a contract to fall back on to attack company B. It can only address hackathons. However, hackathons is not responsible for the disclosure of company B. So this leaves company A unprotected. How have we solved this? We have provided in the general terms and conditions a clause that allows company A to rely on all the contractual provisions that exist between hackathons and all the participating companies, saying that they will treat confidential information of other parties as being confidential information. They will only use the information within the context of the hackathon, and they will not use it for any other purposes, meaning you cannot use it outside the context of the hackathon. This engagement can be invoked by all third parties to each of these contractual obligations. So even though company A is a third party to the contract between hackathons and company B, it can still rely on the contractual provisions in the contract between hackathons and company B in order to claim protection for the confidential information that it has shared with company B at the hackathon, but that company B has disclosed to third parties outside the constraints of the hackathon. So practical takeaways. Before coming to the Open Innovation event, know the background IP of your company. Know which copyrights, patents, patent applications, design rights your company wants to rely on relating to various technologies. Know what you can do with it. Secondly, know the trade secrets of your company. Know which information it considers strategic and you mustn't talk about during the event. Third point, after the event, if you have identified interesting opportunities that you wish to pursue, you need to involve all your team members. So get their information, make sure that you know which persons to be in touch with, and make sure that you engage in an open, constructive discussion about how to pursue this technical and commercial opportunity that you have identified.